Dropped in front of me an article on Denise Richards, which looks like a violation of a previous restraining order in place. Domestic violence is a serious issue, so serious in terms of we call them protections against domestic violence orders. Those orders, when violated, are a first-degree misdemeanor. Here, it looks like Denise Richards was the actual one who came to her estranged husband's house via violation on behalf of Miss Richards. Here, she's alleging that maybe he put a dog down and she went to retrieve her dog. State of Florida, not a defense. You cannot violate a restraining order under any situation. You got to go through the court system. My biggest take is you got to be careful with restraining orders and domestic violence allegations. I'm not saying he hasn't committed domestic violence in the past. I'm saying if she was my client, we'd be having a serious talk. And I'd be saying, look, your conduct of what you're doing now is undermining your position in the case. It's undermining your credibility. You showing up unannounced certainly does not show in any way that you are in fear or imminent fear of becoming a victim of domestic violence. What it's showing to the police, and they've made a record here, but you're the one who approached. So how are we going to stand on this restraining order? And keep in mind, restraining orders are temporary in nature. What you're doing is you're giving credibility to your husband's position that all of these allegations were baseless. In this article, it says she had made some serious allegations at the time that the restraining order was entered. Serious things. Good family law attorney will attack those and say, yes, the validity of those claims are where? Where's the record? Where's the police calls? Where's the bruising? Where's the photographic inventory? Where's the witnesses? Other lawyers are going to say, hey, look, when you're a victim, you take it. And if you feel trapped, that happens. So I'm not here to comment on who's right or wrong. I'm just saying this follow-up conduct hurts the credibility of those stories. A divorce lawyer is going to say, why would you not have called me? I could have filed a motion. I could have spoken with her attorney. I could have tried to defuse this bomb so this doesn't get out in the press. At the same time, if you're her husband's attorney, you're saying, yep, here you go. Look, scarlet letter. The other thing that I would point to as a divorce practitioner, it's not where you begin, it's where you end. Look at the word TRO. Stands for Temporary Restraining Order. For all we know, the other side accepted it because they wanted time and distance away. Maybe they welcome the injunction to say, yes, I would like it to make it reciprocal that we both stay away from each other. You don't really know the total facts. When it's temporary, sometimes it's a different burden of proof, certainly not a criminal beyond reasonable doubt proof. Sometimes a judge will just enter and say, hey, look, we have enough based on what we call the proffer, meaning what we think the evidence would show, where the judge says, I want you two separated and cool down. Now, when courts do that in the public eye, it is a scarlet letter, but it doesn't mean that the underlying allegations are actually truth, meaning it's not where you begin, it's where you end. It could come out that all of this was fabricated, and what I would suggest from my legal take is her attorney's probably not too happy with her. Probably says this type of conduct undermines the credibility of the allegations.